All right. Well, good afternoon, everybody. Hope you all are doing well. I'm sure a few others will be tuning in, but the number seems to have plateaued on our participants. So we'll go ahead and we will get you rolling. Little public service announcement as everybody's filing in. Happy holidays. Don't forget that a 20-pound turkey takes 4 to 5 days to thaw. So maybe this weekend on your to-do list, pull that out of your freezer and put it in the fridge, and you'll be ready for Thanksgiving. So you will thank me later. My name is Ryan Stuart. I am with MBH Settlement Group. I'm in their Old Town Alexandria office where I have hung my hat for the last 25 years or so. So I can't see you all, but there's a good likelihood that the majority of you I have seen at either the settlement table or a previous class. So I do appreciate you joining in here today. I'm going to keep this relatively short. This is not a continuing education or post-licensing credit, but rather just an update on our form changes, and will probably only take us maybe 15-20 minutes or so. So we will get you back to your holiday shopping here momentarily. As we get rolling, and certainly in the vein, speaking of 20-pound turkeys, this ridiculous picture of me was sent to me by a colleague when she made up this advertisement for today's class. I do apologize. Probably never in one screen have you seen that much hair, forehead, and teeth coming at you. But as I was looking at it, I definitely felt like it fit the theme. This is our live breaking news here today. And I knew there was some familiarity to it. It reminded me of my celebrity doppelganger, which of course is the great Ron Burgundy. So stay classy, Northern Virginia. We'll try to take good care of you here today. Let us go ahead and get rolling on the discussion points. This is an NVAR forms update, as you're aware. NVAR typically releases their forms updates twice a year. The forms committee meets throughout the course of the year. They try to update their forms for their constituent realtors, addressing issues of the day, addressing problems in the body of our constituent documents. And those forms are always released at two different times, January 1st and July 1st. And so a couple of weeks before, a lot of us practitioners who like to teach this stuff, we get these forms and we do these types of classes. Now, something unique about this one. This is a special forms update. This one's going to be effective December 1st. So 2 weeks from today, the forms that we discuss here today are going to be substituted in by NVAR. So jumping the gun a bit, a month ahead of time, I am told there will be additional forms that are released January 1st, but this one, once again, a special forms update. And so, it sort of begs the question, why the sense of urgency, right? Why not wait until January 1st of 2024, come out with the forms updates in their regular course of time? Having done this for 25 years, I love these forms updates. I teach classes, I teach sales meetings, and it's tough to come up with new content after 25 years. And so twice a year, I get these forms updates. Well, this year, I get them 3 times. I can only think of one other time in which there was a release that didn't coincide with our January 1st, July 1st timelines. And that was back in the spring of 2020. And most likely each and every one of you remembers what was going on then. The much needed COVID addendum was, I'll say hastily created, how about quickly created, and was put out, was given to you all because quite simply during the height of the pandemic, when everything was shut down, we didn't have the luxury of waiting until July 1st. And so what is so significant now that would parallel COVID, that would require a special forms update? Unless you have been under a rock or perhaps on a deserted island for the last 3 to 4 weeks, I would anticipate that almost each and every one of you is at least slightly familiar with the lawsuit styled Sitzer-Burnett versus NAR, National Association of Realtors, et al., and others, a number of large brokerages. Because I think it gives you context for why the current changes are being made. I want to be sure that everybody understands what's going on in Sitzer and Burnett. These two individuals, Sitzer and Burnett, are not the only two plaintiffs, but they are the named plaintiffs in a class action suit that took place in federal court. These are Missouri home sellers. Now, Sitzer, Burnett, and the rest of their constituent class, long ago, they sold their real property. And when they did, they engaged the services of a listing agent, a listing brokerage. And when they did, they executed a listing agreement, and that listing agreement had within it the compensation that was paid to the brokerages. And it detailed the overall compensation. It also detailed a cooperating or buyer agency compensation to any buyer broker that procured a ready, willing, and able buyer. And the commission due to the listing broker was therefore reduced by the amount paid to the selling broker, and the seller paid their full overall commission. I don't need to explain this to anybody who has ever done a real estate transaction, because it kind of closely parallels what goes on in Virginia and the other 48 states beyond Missouri in which this action took place. Well, Sitzer and Burnett made the argument that this violated federal antitrust law, that it was anti-competitive. And the reason being, what they asserted was that they didn't believe that they should be paying the buyer agency compensation or the commission, right? That agent wasn't working for them. Why were they paying the buyer's agent's commission? Further, they didn't believe that that commission was fairly negotiated. And the heart of the legal argument against NAR was that NAR's clear cooperation policy created this anti-competitive framework that potentially increased broker commissions, or at a minimum allowed broker commissions to be maintained, and to avoid what often happens in a competitive marketplace, which is that competitors will ratchet one another down on price in order to get the client. At least that was the argument. All right. So to understand that, let's look at what NAR's clear cooperation policy is. And this is taken from NAR's handbook that details their multiple listing policy, and is right up front. This is section 1, right? And it says, in filing property with the MLS, participants, that's you all, realtors, you make blanket unilateral offers of compensation to other MLS participants, and you shall therefore specify on each listing filed with service of the compensation being offered by the listing broker to other MLS participants or to cooperating agents. This is necessary because cooperating participants, you got the right to know what your compensation will be prior to commencing efforts to sell the property. All right. That's been that way, I think, since 2004. All right. Now, what's wrong with that, according to Sitzer-Burnett, their attorneys? The first, participants make blanket unilateral offers of compensation, right? Well, that doesn't sound very negotiable. That sounds like it has to happen, right? That listing brokers will always make an offer of compensation to cooperating brokers or buyer agents, right? Shall therefore specify on each listing the compensation being offered. Again, perhaps that compensation could be 0, but it certainly doesn't sound like it from that language. And lastly, that cooperating participants, those bringing the ready, willing, and able buyer, well, you got the right to know what you're going to be paid before you start engaging in efforts to help your buyer purchase that property. That too sort of sounds like, well, if I'm not going to make any money off this, why would I show your particular property? I'm not saying any of these arguments have teeth. I'm just stating that those are the arguments that were made in the Sitzer-Burnett action. Well, what of course happened, I think everybody's read the headline by now. A couple weeks ago, the jury found NAR and others, and these were very significant, large, nationwide brokerages, guilty of colluding to inflate or maintain high commission rates through that clear cooperation rule. And certainly the crux of the headline was the amount of the judgment, $1.78 billion. And of course, federal antitrust law allows for treble damages for violations, potential liability of greater than $5 billion. Yes, all of those zeros are correct. I typed it out with the zeros, even the cents, to show you how much money it was. And then I didn't even do it right. I had 5 million to start. So a big number there, $5 billion. It's got everybody's attention. Well, of course, this has sent shockwaves through the industry, right? A number of copycat lawsuits have been filed: South Carolina, Illinois, Texas, New York, all of those in the last week. And I would venture a guess that each and every state will be subject to some sort of class action litigation, quite simply because that's what these class action lawyers do. They look for a class, they look for a potential cause of action, a little bit of publicity. Ultimately, it's the attorneys that make the very large amount of fees in these class action cases. So they are motivated to do this. Well, NAR came back, as you would anticipate, and they had a response to this, right? And these are NAR's arguments as to why this isn't anti-competitive. And I think each and every one of us could probably make the exact same arguments, right? We're in this industry. We understand the benefits of buyer agency representation. We understand the dynamic of how it's paid and so forth. Agent compensation set between brokers and their clients. It's always been negotiable at any point in the transaction as set forth in the guidelines, right? And those costs are explicitly spelled out to buyers and sellers, right? Net sheets, agreements, and so forth. Further, from a policy standpoint, if buyers had to pay this compensation out of their own pockets, it would have a chilling effect on our real estate industry, right? Buyers aren't factoring in this significant cost. The argument here is that the costs of selling a property are already too great. Well, now the cost of buying one would be too great anyway, right? And so particularly low income buyers, perhaps low money down buyers, the VA community comes to mind, where many loans provide 100% loan to value. Obviously, this is going to have a significant chilling effect on those buyers' ability to purchase a home if that were to take place. Further, every plaintiff, and this is every home seller, because those are the ones filing the action, they knew the commission they were paying to their agent, and they agreed to it in writing, right? That's why we have brokerage agreements, and specifically in Virginia, where it is a mandate that in order to create that agency relationship, it must be done pursuant to a written brokerage agreement. That's for buyers or sellers. And finally, that clear cooperation policy, what does it do for policy reasons, right? It ensures representation for both sides, right? We have had a framework in which buyers didn't have representation. It was about 40 years ago, right? Basically, both realtors to the transaction represented the sellers. It was called sub-agency, right? The seller negotiated an overall commission. They extended that out to sub-agents who would essentially work for the listing brokerage and on behalf of the seller to find that ready, willing, and able buyer. And of course, buyers didn't have adequate representation. There was an uneven playing field. So this type of system really doesn't work according to NAR. All right, so what does all this mean for you? Well, I've got, I guess, a trio of answers, right? The first is that it's premature for us to determine what this means for you, right? This judgment was rendered a week and a half, 2 weeks ago, but it's on appeal, as you would imagine, and it's going to be on appeal for a significant period of time. Pretty much everybody has lawyered up with the big starch shirt, fancy New York attorneys who do this sort of appellate work. The defense arguing that this judgment should be overturned. Even in terms of an immediate impact, right? The plaintiffs in this action called for an injunction, basically a halt to that clear cooperation policy. Even that's being appealed. That's set for discussion, I think, in April. So it'll be really 5 months before we see anything on this. And so the prevailing answer is, what does it all mean for you at this point? It means nothing. So it's not the death of buyer agency. It's not the death of cooperating agency compensation. It does not mean that you go into every single one of your listings and it is only the listing brokerage compensation that is paid by the seller, right? None of those are definitive at this point. Your world is not changing, right? Now, everybody keeps asking me, Ryan, what do you think it means, right? Look into your, read the tea leaves, right? Look into the future and see what this means. For me, if I was to distill all of this down, it keeps reminding me of a case that's probably familiar to many of you. Back in the early 90s, a lady named Stella Lieback was sitting in the passenger seat of her car. She got a hot coffee from McDonald's. She pulled off the lid, went to put the cream in, and the coffee spilled all over her thighs, causing third-degree burns. She sued McDonald's. Anecdotally, she only sued them for $20,000. They never offered more than $800,000. This thing went to a litigation, and Ms. Liebeck got millions of dollars in damages, most of them punitive, against McDonald's by virtue of them selling hot coffee. Now, of course, everybody wants their coffee to be hot, right? So what happened in the wake of all this? When you order a coffee now from Starbucks or McDonald's, do you get lukewarm coffee? No. You simply get your coffee with a warning on it, right? Caution, your coffee is hot. This is the fallout from this entire action. Avoid pouring coffee on your crotch area. That's a fairly explicit coffee warning there. Also, incidentally, when I was going through this, I saw that this was translated into French. The language of love, evidently the crotch area in French is referred to as the l'area de oulala. Great stuff. This is where I see this thing going, right? I don't see the entire framework of our transactions changing because, quite honestly, if you look at the trickle down, again, we would go back in time 40 years and we would go back to a world where buyers do not have representation because every other avenue just simply doesn't work. And so what it means is that we're probably going to see much greater emphasis placed upon the negotiability of brokerage commissions. All right. The third and last thing that I think it means for everybody is you guys get a forms update from Ron Burgundy. So let's go ahead and get into that and just talk about what's changing effective December 1st of 2023, 2 weeks from now. And the primary updates are to our listing agreements, K13, 36, and 37. For our purposes today, these are exactly the same. And as I will point out a bit later, it's also the same changes for sale of unimproved land and for rental properties. You're working with a landlord leasing a property, so too are these changes being implemented. All right, so this is our current language. And by our current language, I mean the language up until the 1st of December, 2023. Broker will make a blanket unilateral offer of cooperation and compensation to other brokers. In any MLS that broker deems appropriate, to that end, broker will offer a portion of the compensation to the cooperating broker as indicated. All right. Now, what's potentially problematic about this if we look at this in the light most favorable to Sitzer-Burnett? The first, broker will make, right? That's far too conclusory. That sounds definitive, right? That sounds like there is definitely going to be a buyer agency compensation or a cooperating agency compensation being offered by the seller, right? It also seems pretty unilateral. They even use the word above, but that broker deems appropriate. Now, they're of course not referring to the commission piece that the broker deems appropriate, but where it's being listed. But nonetheless, very, very one-sided, seems to maintain that it's the broker making all the decisions here, or that it's as it always has been and as it always will be. Again, this definitive language, to that end, broker will offer a portion of the compensation, right? All right, so let's look at our new language. How has the compensation paragraph of the listing agreement been changed? And this is specifically with respect to the cooperating agency compensation. We now style this buyer agency compensation. And the first thing that we do is it gets defined, right? This is our new paragraph. Buyer agency compensation is an amount taken from broker compensation. Broker compensation is what's been agreed to in paragraph 12A as the overall commission. So it's taken from the broker compensation and paid to any broker representing the buyer in this transaction. Far more than the previous language, almost seems to be setting up this contractual agreement to pay the buyer agent as opposed to paying the listing brokerage and then the listing brokerage paying the buyer agency compensation. Here, you're paying the listing brokerage, and if there's a buyer agent that comes in, your commission gets reduced, buyer agent gets theirs, and so forth. Perhaps that makes a difference to somebody. Now we've got this awareness, right? Seller is aware that the buyer agency compensation can be any amount, right? Now that's language that wasn't in the language before, right? It's negotiable, right? Next up, broker and seller agree, right? Not only do we have this awareness, but we've got this sense of agreement. No longer is this some sort of unilateral decision as to how it has to be, but we're coming to an agreement as to what we may pay in buyer agency compensation if somebody procures a ready, willing, and able buyer. And then we've got this little tickler down here. Broker and seller agree the buyer agency compensation, if any, will be. Now, this was subject to a lot of discussion with the Forms Committee, and I trust with every other realtor association out there, right? Does it even belong, right? We've already said above, right, that it can be any amount. Do we have to say if any? I think some of the Forms Committee wanted it to be zero, right? Let's go further in that direction. Ultimately, for now, this is what they've settled on. All right. So we now have this argument that it's negotiable, that there doesn't necessarily have to be a buyer agency compensation that is being offered or paid by the seller out of the overall broker compensation. The disclaimer language that's right below the compensation paragraph, it's boilerplate. This is the language that's always been in there. Broker compensation and the sharing of compensation, between brokers, it's not fixed. It's not controlled, recommended, or suggested by any MLS or association of realtors. Language has been updated, right? New language, fully negotiable. Again, adding in there that sellers and their listing agents or listing brokerage can fully negotiate the overall compensation, including any commission that's being paid for buyer agency or cooperating agency. And similarly, it's not fixed, controlled, recommended, or suggested by law. Again, don't know what difference that makes, but it's making the seller ostensibly aware that there's no law that requires that you pay buyer agency compensation. All right. So again, your coffee is hot. That's the direction that we seem to have gone with this overall this listing agreement. Nothing has changed, right? It's no longer saying, or it's not saying anything to suggest that buyers have to pay their own commission, that sellers can't pay the buyer agency commission, on and on and on we go. We've just got this conditional language, this negotiability element to soften up the overall impact of the listing agreement. Right? Now, who benefits from this updated language? Arguably every change that NVAR does, right? They are an association of realtors. So the Forms Committee makes these changes with you all as its constituents, as its agents in mind, right? Presumably you benefit from this language, right? This is putting it out there to the public that commissions are negotiable, which means that you should not be subject to any sort of antitrust action for fixing prices, for inflating commissions, and so forth. Right? Now, whether or not that ultimately is true, we'll see. As an agent, how should you change your standards of practice based upon the lawsuit and the updated language? The one thing that seems to be recurring over and over again, I don't know anybody that does this, but if you are an agent that is pre-populating your agency agreements, if you come to your listing presentations with it already filled in, this is what I charge and this is what the buyer agency compensation is going to be, that's a no-no. You don't want to be doing that, right? Similarly, any discussion that you're having with your clients that says, well, you have to pay the commission, that's just the industry standard in Virginia. Well, that's wrong, because it's not the industry standard. It's not required. It's not by law. It's by negotiation. It's by contract and so forth. But to go any further than that, number one, is premature. And number two, it's not my role as your preferred settlement attorney to be making these assertions as to how you should be changing your standards of practice. This is going to be for your brokers to decide. Ultimately, it's your brokerage that maintains your E&O insurance and protects you against these types of claims. And so I trust that this will be a pretty consistent source of discussion between you and your brokers in the coming weeks, the coming months, if it is not already. And so it's not water that we're going to wade into today. All right. Let's talk about a couple of de minimis changes. The broker service fee, many brokerages have them. It's in addition to the brokerage compensation, a flat fee, minor change. The new language just took out, it doesn't need to be paid in cash, which seems obvious, but a bit of an odd bit of language that was in there before. And then paragraph 10, which is our marketing MLS, internet paragraph, we've got title headings that are added just for clarity, MLS marketing, third-party websites, and coming soon. Guys, as I mentioned before, these changes that we've discussed have also been incorporated into the listing agreement for unimproved land and for leasing properties. You'll see the exact same changes have been made. And then lastly, we want to talk about changes that were made to the buyer representation agreements, because of course, anything that impacts the cooperating agency or buyer agency compensation, despite the fact that it's between the seller and the listing brokerage, also has a trickle-down effect on buyers. And though none of these actions so far have been from purchasers of real property, I think it's important that we understand the trickle-down effect. And similarly, it's a coffee is hot type of moment, right? This applies to both purchases and rentals. We've got our current language, right? I'll highlight the important parts, right? Talks about a buyer paying a compensation piece, a percentage of the gross sales price or a flat fee, the extent they go to settlement on a contract. In most cases, the seller pays the broker's fee. Again, conclusory, right? Kind of flying in the face of the Sitzer-Burnett verdict, or certainly not as soft a language as we would like, right? Similarly, in the event the seller does not pay any or all of the amount due, then of course the buyer hereby agrees to pay all the remaining fees. This is our new language. Pretty much exactly the same, but for the last couple sentences there, we now know that the buyer is the one responsible for paying the broker fee at settlement. Now, if the buyer receives any compensation from the seller, of course, that amount will be credited towards the buyer's obligation to pay the brokerage fee. So that framework that you all are accustomed to, I'll say. By accustomed, I mean that has happened in the great many of your transactions, and certainly the great majority of the transactions that I have ever closed, in which a listing broker extends a buyer agency compensation. That framework still continues to hold true, within the body of the buyer representation agreement. Again, the conversation should be had with your purchasers to say that quite often a buyer agency compensation is being offered by the listing brokerage or by the seller. But to the extent that it's not, obviously you still get your brokerage fee and the purchaser would be responsible for it. This too is negotiable. This too shouldn't be pre-populated in any manner. And perhaps it goes without saying, but of course you should not in any way be refusing to show properties that have a compensation less than what you have in your buyer representation agreement. That lies at the very heart of the great majority of antitrust actions that have ever taken place in the real estate industry. So cautionary there. Guys, with that, they've added the disclaimer as well and neglected to mention the same exact language as in the listing agreement. All right. But with that, that's everything we need to talk about. As always, I'm long-winded. We went 30 minutes instead of 20. If there are any questions, I'm certainly happy to stick around and address these after the fact. But for those of you that want to go, certainly no new information here. Keep in mind, we do teach these classes, one, because we love you. Two, because we want you to be educated. We want you to do the best job of representing your clients. But ultimately, we do it as well because we want to see you at the settlement table. We're in business. I've got kids. I got to put them through college. So if you have the opportunity, certainly reach out. Be happy to work with your buyers, your sellers, all parties to the transaction. We'll give you a really good settlement experience. So for those of you that want to sign off, have at it. I'm going to go ahead and pad through the questions now, and we'll go from there. Happy holidays. Happy Thanksgiving. All right, so first question, Tina Perry, do we have any handouts? I would be happy to send the PowerPoint to my colleague, Beverly Franklin, in our office. You are also welcome to email me at rstuart, that's S-T-U-A-R-T, at mbh.com, and I'd be happy to share it with you. At the same point, you can get these new agreements through NVAR here very shortly. Zoma, 23-pound turkey, good for you on Wednesday. Wish the entire recording was mandatory viewing, as do I, but we'll go from there. Copy the slides. Yes. Does this mean if no buyer agent, then total commission is the lesser amount? It does not. Paragraph 12A details the overall broker compensation being paid. So let's say that that is $1, right? Let's then say that in paragraph 12C, a buyer agency commission of 25 cents, 50 cents, 75 cents, whatever is being offered. To the extent there is no buyer agent, the overall broker compensation of $1 is still paid to the listing brokerage. Good question. Lots of thank yous. You are all very welcome. Is the video being recorded? Yes, it is. And we can get you out a link, or you can email me and I can get that to you. So go to happy Thanksgiving to you. May have missed it, but is there a place in the buyer agency agreement that accommodates the admin fee? Yes, there is. That remains in there. It's in, I think, paragraph 8B. Any suggestion on how to help VA buyers when there is zero cooperating agency compensation being offered? You could negotiate a closing credit, perhaps, from the seller. You want to be sure with your lender that they are perfectly fine with getting that brokerage commission credit from the seller, or that it's okay to offset the buyer agency compensation with that seller concession. Certainly making sure that your VA buyers understand the framework of your buyer representation agreement. We love this home. There's no cooperating agency compensation being offered. I do have my brokerage agreement with you, and so we do need to find a mechanism to be sure that my brokerage and I are paid for our efforts. But again, I'll leave the rest of that dialogue to you and your brokers. We're signing a listing agreement in the next week. Should we preview this new language with sellers? So Lori Lovejoy, great question. So what NVAR, NAR, and your brokers hope is that you are having a discussion with your clients already to detail that brokerage commissions are negotiable, that this is why your services are of value. These are all the things that you can do to justify that commission. Explaining to them as well how buyer agency works, right? But that even that buyer agency compensation is a negotiable payment. In terms of showing them this new document, all you'll see so far is an educational version. So if you want to show it to them, have at it. But hopefully you're engaging in the exact same practices as you already have been up until this point in your real estate career. Again, nothing is changing with regard to your obligation, your client's rights, and so forth. I've already talked about VA loans and HRH, always very informative. Have a great Thanksgiving. All right, guys, with that, I think we've addressed all of the questions, at least for now. I'm sure every single one of you's got a half a dozen questions that you'd probably like to go through. Reach out to your local MBH settlement attorney. I'm certainly happy to have these discussions. Reach out to your broker. NVAR is obviously a great resource for you. And really more to come on all of this. We are purely scratching the surface. And at this point, certainly there's some smoke on the horizon, but nothing has changed. Okay. So have a great Thanksgiving. I wish you all the best.